Just advise members, this is a split call. I call the Honourable Member Claire Curran.
Thank you, Mr. Speaker. In the second reading of this bill, I'd just like to start off by saying that on the 27th of June in 2012, so that's the 27th of June last year, an article appeared on interest.co.nz that said that New Zealand's removal from the white list, which is a European Union list of financial institutions and banks that could undertake additional measures to ensure customers, including companies from New Zealand who are who they say they are. New Zealand got dumped from that list, Mr. Speaker, a year ago. Almost a year ago. It was a year ago. And that dumping came amidst growing publicity around New Zealand's registered companies being linked to crime overseas. And there was a report by the Organised Crime and Corruption Reporting Project on how Tormex Limited, which is a New Zealand registered company, allegedly laundered $680 million through a Latvian bank account. This was just one of many examples of the entities that were exploiting New Zealand's simple company registration regime, and I could go on to list more, but I won't. The issue, Mr. Speaker, was that there was a case. The question of whether there was a case for criminalising directors' statutory duties first arose in the Ministry of Economic Development's, as it was known then, 2010 Securities Law Review discussion paper, and it was later approved by Cabinet in 2011 as part of their policy decisions on securities law reforms. And there were two Cabinet papers, as I understand it, that related to this from 2011. It's now 2013. It took 18 months for a piece of legislation which was identified as being so important that had New Zealand struck off a white list, it took 18 months for that piece of legislation to appear in the House for the first time, Mr. Speaker, for the first time. And then, and I think its first reading was on the 24th of July last year, and then it's taken another year for it to get to the second reading. Another whole year. Now, when you think about, the fact that we were struck off this list, and it was seen as part of our international reputation as being a good place to do business, as being an easy place to do business, but also as being a sound place to do business, you would think that that would be a piece of legislation that this government would treat as being important and urgent. Instead, we have many other pieces of legislation that suit their agenda, which get rushed through this House under urgency, and something as important as this, which had broad support in the Select Committee. There were serious discussions amongst all of the members involved, but ultimately good work was done to produce a piece of legislation that is sound. No doubt it's not perfect, but it was sound. Good work was done to do that, but it's taken another year to get to this point. I want to talk about a couple of points in this legislation that particularly stood out for me sitting on the Commerce Select Committee, and I would also like to take the opportunity to thank the officials for the work that they've done and the good, sound way in which the analysis was provided to the committee. This bill seeks to do a number of things, but I'll talk about a couple of them. One is the introduction of the criminal sanctions, which is to be done in two ways, really. Some of the existing conduct by directors that isn't currently subject to criminal sanctions, which was considered sufficiently blameworthy to warrant criminal punishment, that is seen as being one of the areas which needed attention. We also considered that the new provisions in the bill that would allow, in certain circumstances, certain contact that was already subject to criminal sanctions to be prosecuted more directly. So there was new criminal sanctions and there was existing criminal sanctions that would have perhaps stronger criminal sanctions attached to them. The committee did take care, though, to ensure that the directors and advisors in companies would not be inadvertently criminalised through this legislation, and there was a lot of discussion on this issue. We went backwards and forwards on that because and it would be important to note in this House that this side of the House does not want to produce legislation before this House that creates a chilling effect on innovation and on companies being able to do what they do best. But what we do need to do is provide the sanctions that prevents and punishes the behaviours that we want to produce, and the behaviours for which New Zealand found itself struck off that white list in the European Union, and for which we should feel ashamed, in particular ashamed that we didn't actually act faster on this piece of legislation. The second, just on that point, Mr. Speaker, those criminal offences for directors who commit a serious breach of their duties to act in good faith and in the best interests of the company and not carry on their business in a way that risks serious loss to the company's creditors, directors who commit those offences will now be liable, as I'm sure you've heard today, for imprisonment for up to 5 years or fines of up to $200,000. We listened carefully to the submissions on this. We heard that there were a number of submitters who were reluctant and expressed concern about increasing those penalties, but ultimately the committee, I think, came down on the right side on this issue, that we had to show that we took this issue seriously and that there would be serious penalties for directors who weren't acting in good faith. Linked absolutely with this is the requirement for directors to ensure that there is a director of the company, which I know other speakers have spoken about, that a director who lives in New Zealand. We thought absolutely that we had to address this issue because of the shelf companies that were being established in New Zealand where there was no person associated with them and were effectively being used as money laundering organisations, and that we have to have legislation in place that addresses that issue. We also had to ensure that there could be balance achieved by requiring a company to either have a director who lived in New Zealand or who lived in and is a director of a company with which New Zealand has reciprocal arrangements for the enforcement of low-level criminal fines. There was, again, a lot of discussion on that point as well, and the purpose of requiring a director who lived in New Zealand was to ensure that there was going to be an identifiable person, somebody who actually existed, not somebody who potentially existed or where there was just an address with no actual company behind it. An identifiable individual with a substantive connection with the company who could be questioned about the activities of that company and who could, in certain circumstances, be held to account. That was the important test that we in the Select Committee agreed upon. There was a lot of discussion, and we also noted that there were a lot of submissions, again, that raised concerns about that particular point. But in the end, the committee came down on the side of the advice that we were given, that where we disagreed that a resident director would not be effective in preventing the misuse of New Zealand's company registration system, and of the companies that have been identified as being involved in money laundering, fraud and tax evasion in overseas jurisdictions, the vast majority do not or did not have a New Zealand resident director. And I think that is the important point here, and that is the point that, and one of the key parts of this legislation, is to ensure that if there is a company operating in this country, that there has to be somebody who is a person who is associated with it. And the information that we received was that this wasn't going to create an enormous financial burden for companies, and because there was less than 1% of New Zealand registered companies who didn't have a director who lived either in New Zealand or Australia. So, Mr. Speaker, we support this bill and look forward to further discussion in the committee stages.
Point of order, the honourable member.
Sir, I came at the earliest possible convenience. But I would like to ask for your considered ruling in the time available before the conclusion of this debate as to whether the Royal Succession Bill, the next